Next case is case number 527466, matter of Doe versus Rensselaer Polytechnic Institute.
Good afternoon.
Thank you, Your Honors. May it please the Court. Michael Ginsberg of Patterson, Sampson, Ginsberg, and Griffin for the appellant. Your Honors, the lower court's conclusion that the appellant, a private educational institution in this matter, violated Mr. Doe's constitutional rights was a professed and deliberate yet erroneous determination by the lower court. In Rohrbach, which is cited in our papers.
You're not making any argument about the jurisdiction finding that you folks didn't have jurisdiction to do what you did?
Correct, Your Honor. I don't necessarily agree with it, but we're not appealing.
That's what I mean.
Yes.
Okay.
This is simply as to the
Dicta.
court's determination that a private entity violated someone's constitutional rights, which I will note for the court is a legal impossibility. In Rohrbach,
So RPI can go out, investigate anybody they want, whenever they want, and it's a legal impossibility that that would violate my constitutional rights?
correct, Your Honor. Only state action.
Seriously? They can go investigate me, bring a charge, when I've never been on that campus and I'm not a student, and that doesn't violate my constitutional rights?
Judge, I would hope that they would consult with me first. But, correct. A private individual or entity cannot violate someone's constitutional rights. It must require state action. In fact, one of the leading cases on that matter was addressed by this court in 1999 in Rensselaer Society of Engineers versus Rensselaer Polytechnic Institute, a matter which my firm handled.
Counsel, if you concede, and I'm not asking you to concede this, but if you did agree that this was just dicta, you wouldn't think it would be appealable, would you?
No, dicta is not appealable.
Right. So,
I agree.
Okay.
But this was not dicta. The Rohrbach case handed down by the Court of Appeals addresses what dicta is and states, opinions of a judge which do not embody the resolution or determination of the court and made without argument or full consideration of the point, which are not the professed deliberate determinations of the judge himself. That's not what happened here. What the judge did was say, RPI lacked jurisdiction and they acted arbitrarily and capriciously, and in doing so violated his constitutional rights, and that is the basis of my determination.
but the main reason here really was that they didn't have jurisdiction to do this because this fella didn't go to school there.
Well, why come to a conclusion then that his constitutional rights were violated? And Judge, if I may,
But isn't that right? Wasn't that the main thrust of this, his primary ruling? In fact, in the motion to re-argue, didn't he clarify that and actually say that?
Well, I would submit that the motion to re-argue is not before this court. It's not appealable, and it was not the basis for the court's earlier determination. The fact that the same court later said this is only dicta, I believe is immaterial because the underlying decision is erroneous and clearly not dicta. And this is what...
Right, you say it's dicta.
I say it's not.
You say it's not, but the court says it is.
Correct. And realistically and practically, if that was the case, why didn't the court just remove it? But here's what the court said, Judge.
Well, the court sometimes
Maybe the
put
court
dicta.
wanted to say it.
Yeah.
Yeah, because that was the basis of the determination.
Or it was an observation, not really a basis of...
Isn't it tied into the, I get this in my mind that, well, let me ask you this, and then what was the jurisdiction here of RPI to
Well,
investigate this perpetrator?
Title IX requires an investigation.
Of a this
Yes, of a
perpetrator
non-student.
here is
Any report of sexual assault under Title IX requires the receipt of the complaint and an investigation. Doesn't matter who they're complaining about.
And where the supposed acts occurred off campus?
Yes, but the school still needs to investigate as to whether or not that constitutes a threat to the individual or the campus at large or a program.
Why, when, well, I guess what I'm struggling is, why when the university operates under color of a federal statute, can't they violate constitutional rights? This is a federal statute that the school is claiming gives them the right to do it. Correct?
I don't-
Title IX requires investigation.
It does, but they're not operating pursuant to Title IX. Title IX is an obligation that be followed. It's like any other law. I mean, it's a law, and it's got to be complied with. You're not operating under it. You're operating pursuant to it. Let me ask.
What gives them the authority to do this?
What gives them the authority to operate under Title IX?
No, what gives them the authority to investigate?
Well, one, their policy, and two, Title IX mandated at
Which
that
is a
time
federal
that they
statute.
investigate. I'm sorry, Judge?
Which is a federal statute.
Correct. But it doesn't confer constitutional requirements upon them. In fact, recently, I argued a very similar case in front of the Northern District, and the court also acknowledged that a private enterprise cannot violate constitutional rights. This is not an open question.
So what's the impact upon your client of the fact that this line, apparently erroneous, and in fact, the judge, as much as acknowledges that in the further document, the renewal re-argument, the judge says, I didn't mean, it was dicta, and what's the impact of that on your client at this point?
You have a judicial determination that the institute violated someone's constitutional rights. Wouldn't that be actionable?
In this
That's what we're
circumstance
seeking
where,
to protect.
you said, I heard you assert that, well, that renewal re-argument is not before you, but we take judicial notice, as would any other judge or, court, and so it has no real impact at this
Well,
point.
Judge, let me read what the decision of the lower court was. And I think that's where it's indicated that this was well thought out. He's not making an off-the-cuff remark.
The second decision or the first decision?
The first decision. It says, even if the court were to have found that RPI had jurisdiction over petitioner, the procedure followed by RPI in this case was arbitrary, capricious, and in clear violation of petitioner's rights. It is obvious to the court from a reading of petitioner's interview, and here he gets into the application of the facts. Petitioner's affidavit and exhibits in the record before the court that there existed a language and a possible cultural barrier that resulted in miscommunication and misunderstanding between petitioner and respondent's interviewers. Respondents contacted petitioner and requested a meeting and never notified him of the reason for the meeting. Before the meeting began, the interviewers informed petitioner that he was the subject of a sexual misconduct complaint and gave petitioner a number of important documents relating to the investigation and his rights, and only gave him moments to consider them. That's a due process argument.
Right, it's an alternate holding, completely alternate. You're saying it's a holding.
I haven't even gotten to it yet. The court finds that the conduct demonstrated by respondents towards petitioner during the initial course of this investigation was a clear violation of his constitutional rights. And here's the operative sentence. Accordingly, based on the foregoing, the petition is granted. He granted the petition based on all of those issues, not solely on the jurisdiction issue. Otherwise, he would have said, the petition is granted on the basis of the jurisdiction issue, and by the way, I think this.
So
Do you
maybe-
agree? Do you agree on the jurisdictional finding?
I don't, but it's not of consequence to appeal because the policy is.
All right, what are you asking us to do?
I'm asking you to strike the language in the decision or return it to Judge Elliott to strike that language, holding that there was a constitutional violation. The rest of it, we are fine with.
You
Why
ever heard of
can't
an
we
appeals court doing that?
Well, it's an erroneous determination. Of course it can be sent back.
But you're not asking us to reverse the bottom line. You're just asking us to strike certain language in the middle of the trial court's decision. And
I'm
then
asking you to
let's,
strike a determination of the court,
And
which
let's-
was clearly
but-
erroneous.
but let's stand the order.
Yeah.
So
And
you
it's
would,
the
you
whole
would,
paragraph you want us to strike, or just that sentence, which is
Ju-
an issue?
Just the sentence would be fine. The issue here is the.
Because the judge says, the court agrees in the later decision, let me read to you now. The court agrees with petitioner that the paragraph containing this sentence is dicta. I think he's actually saying the whole paragraph is
Well,
dicta.
He says it's dicta, but he doesn't say that it's wrong.
Why is it, why don't you go back to the court and say, can you clarify, can you strike, can you do this? Then if your request is denied, then you appeal that.
That's what
Why-
happened, Your Honor.
That's we
I
have
made a motion to
we
re-argue
have
it.
the renewal re-argument, but the renewal re-argument says the paragraph did not in any way change or address the issues before the court. The court had already ruled that respondents acted arbitrarily and capriciously as they did not have jurisdiction.
I understand, Judge, but
So-
that is not the standard for whether something is dicta or not.
basically, you want us to say, we affirm, albeit on different grounds, and say, we affirm based on lack of jurisdiction.
No, essentially, yes.
That's-
And
that's
that
what you're asking.
determination is strict, or reversed, or
Whatever
Well,
that
not-
reasoning, that's what you don't like.
You're not asking us to condone the conduct, are you?
No, of course not. Your Honor, the judge made his determination. I don't agree with it. There is evidentiary support for his conclusion.
See, I think that if you challenged the whole shooting match here, both points, you challenged the jurisdiction, and we said, no, you're wrong on that, then maybe we could get to the next point. But without you challenging that, I think you're just challenging something that will have there's no impact. It's just in your mind's eye, kind of. It's not a legal impact, and that's why I think it's dicta. Do you know what I'm saying here? I'm not saying you don't have, even if you have a point on the dicta. A lot of people have points on dicta. Dicta could be wrong. That doesn't mean we take it up on appeal. It's not appealable if it's wrong necessarily.
Well, Judge, I agree, but the core issue is this dicta or not? And I submit to the court that it's not, because the last operative sentence of the decision captures that argument.
It might inform it to some extent, but if you took it completely out, if you excised it, you still wouldn't have jurisdiction to do what you did as an institution. So it wouldn't change anything.
No, the ultimate determination, well, the ultimate result of the case does not change. But that doesn't mean that that determination from the lower court is immaterial.
Okay. We have used your time and then some.
Thank you, Judge.
Thank you.
Good afternoon, judges. May it please the court. My name is Brett French. I represent the respondent, John Doe, on behalf of Chief Irving and Savage.
Is this proper to bring this issue before this court?
No, as I briefed, Your Honor, I would argue that this is an appeal of dicta, and no appeal lies with dicta. The argument's illogical. It's asking the appellate division to find a statement to be a determination in order to reverse that determination so it no longer has the holding or rule of law. Dicta does not carry with it the rule of law. So it's, I guess, this long roundabout way of getting it to be considered the same thing as dicta. I don't know why we're here. There's, as was mentioned, there's no other issue that's being appealed from. Quick note, I would disagree with appellant's counsel that no private action can be deemed state action or quasi-state action and carry with it the possibility of violating constitutional rights. There's several federal case law as well as state case law that I did cite to you in the brief. There are 4 different ways in which private action can be cloaked with that of which is state action in order to, and with that, bring with it the repercussions of that, which would be, a violation of constitutional rights by a state actor. Appellant's reply brief goes on to argue that respondents' argument in the alternative, that if we are going to be having this argument here today that this is not dicta, that there still is this possibility and that it is, that there is evidence and it's well supported in the record for such a determination. Appellant's counsel makes the argument that respondents' counter alternative argument is the evidence that this is not dicta. Again, these are roundabout ways of getting us here, and we shouldn't be here in the first place. And that's we asked the lower court. It was not done so through a cross motion. This is a case that we are dealing with a person of very limited means, and it was asked at the lower court stage with the motion to re-argue as to whether or not the court would take up the issue of sua sponte sanctioning RPI basically for bringing a frivolous motion to even re-argue when nothing else was presented there. And again, we do reiterate that here before this court, understandably that a sua sponte issuance of sanctions is relatively rare and not something courts often bring up. But we have a lower court even clarifying its decision, saying this is dicta, and now
But the appellant is concerned, the institution is concerned about the potential impact of having such strong language out there in a determination that is apparently still standing, and that language might be misused. And can't you envision some way in which that would occur?
Well, Your Honor, I would first, a short answer, no, because we're saying misused. And if RPI was concerned with how their actions would be held accountable in the future, they likely shouldn't have performed those actions in the first place, not worried about how a judge is going to opine on those actions. Second, I would say there's no collateral estoppel effect here by this statement that these actions were against John Doe's constitutional rights. With that said, the paragraph does address, and it is shown through the record that the manner in which John Doe was contacted, the manner in which he was interrogated or interviewed, not only violated, it was not simply this violation of constitutional rights, but it did also go against Title IX directives as to the notice that is proper to an individual, regardless of whether the investigating institution is a state actor or not. So those were arguments that were made in oral argument for the injunction, also in chambers with the lower court, that were taken up and accepted by the lower court. Now, this final conclusory statement that, his constitutional rights were violated, well, I don't disagree that that's actually the case. I think that this is one of the most unique examples of a quasi-state actor probably violating someone's constitutional rights. We have a school attempting to fill the shoes of what is traditionally done by a public university, which is that disciplining their own students. And this student would always, if ever disciplined by a university, be given the full panoply of due process rights. They knew that, or at least they should have known that, and led this individual to believe that they had jurisdiction over him, that they could interrogate him, and then also that they could share this information in a joint effort, if you will, with this man's institution. So if ever one of the four elements we look to is whether or not whether private action can become state action, is whether the private actor takes on a role that is fundamentally performed by a state actor. That's obviously met here. Another is where a private actor may act with a state actor. If a person on the street is assisting in a citizen's arrest along with a deputy or a police officer, and that citizen gets called in or is working in conjunction with a private officer, they're going to be treated as a quasi-state actor because they are joining in They are taking on, they're cloaking themselves with this authority that is state action. So with that, Your Honors, I would rest.
One last thing.
Absolutely.
Would you be arguing that, then, I mean, I'm hearing you, and I'm thinking you're arguing that the fact that it was arbitrary and capricious and in clear violation of petitioner's rights was a necessary finding in this case, that the court was required to make such a finding?
That
it was
yes,
integral.
so it was
that
in
it was-
excess or outside of jurisdiction was one of the arguments that they're.
That was
they're-
after the jurisdiction, that it was the line here, the beginning of the paragraph is that, that the RPI, even if RPI had jurisdiction, the procedure followed was arbitrary, capricious, and in clear violation. Was that integral to the determination?
Yeah, I would say it was, Your
If it
Honor.
was,
And
it was
those
not-
rights, though, not his constitutional rights. Violation of his rights with regard to how Title IX treats individuals. The issue of jurisdiction also points to how the respondents at the quasi-administrative stage are treated, right? So there were also rights that are afforded this individual, notwithstanding constitutional rights.
Can I ask one question?
Yeah.
Thank you. So I just want to get you back to res judicata collateral estoppel issue.
Sure.
If we found that this is dicta, okay, and then your fellow decided to bring some kind of action against RPI for some kind of damages, there wouldn't be any res judicata effect that this judge said in dicta that they violated his constitutional rights, correct?
I would agree with you, Your Honor, but I would also have my agreeance would have a caveat that I don't believe this court can take that into consideration anyway.
I'm just wondering about the legal
no,
effect. I think you're the one who raised the res judicata issue.
Right, and whether or not the individual would be bringing a separate action, I can't speak to that, but, right. I do agree, Your Honor, yes.
Okay, thank you.
If there's nothing else, thank you.
Thank you both.
All rise.
Thank you, Your Honor.
This court is now adjourned until Thursday, March 21st at 1:00 p.m.